Okay, I think it's time for me to introduce our main speaker, Ollie Richbell. I'm not quite sure what to say about Ollie. Um, first of all, he's a very, very nice man. Secondly, I consider him to be a good personal friend, as well as a mediator. And some of you may know that he's a chip off the old block. Behind him is a photograph of, unfortunately, his late father, David Richbell, who was one of the very leading lights and early lights in mediation. I did two of my first assistantships with David, and he was extremely good, although I have to say neither of them settled. Sorry, Ollie. So over to you, Ollie, if I may.
Thank you, everybody, and welcome to everyone. So great to see so many new and first-time attendees. Fantastic to see us all, and I hope that we're all well and keeping safe, and hopefully we'll have an interesting 45 minutes or so. Short bit about the DRP, formed in 2015. I was a former litigator. David and I, Dad and I, came together and talked about early concepts of dispute avoidance. How can we help businesses avoid the rigors and stress and test of litigation, court-based disputes, or just general disagreements? And along the journey of the DRP, we are super happy to have a number of consultants, Wolf von Kumberg, Azaza El-Sheikh, Stephen Hall, David Evans, and Ian White. And together, we all wrote a manual, a how-to, if you like, or a little guide that we pithily called Volcano Insurance, but I'll explain that in a second. And that was published in May 2020 by Urbane Publications. It's very simple. The DRP passionately believe that it's better to avoid a dispute than resolve one. Avoiding a dispute can mean less financial outlay, dramatically decreased management time, minimized, if not eradicated, risk, and a far greater opportunity for repeat and expanding commercial opportunities. So this morning, I'm going to be talking to you all about dispute avoidance and the immensely positive impact assisted deal making can have on the preparation, negotiation, and of commercial contracts. And hopefully, I'll be encouraging some debate and hopefully some collaborative engagement about the topic and the concepts raised today. But before I begin, I think it's only right that we express thanks, as always, to Dave Owen, Martin Poulter, and Michael Cover for arranging yet another Mediation New Breakfast Club event online, as well as obviously my thanks to you all for joining. And I think it's a testament here to everybody that we are, we're able to have these events and they can continue, and they're as popular and as they ever were before. And obviously, I hope that sooner rather than later we can all meet in person again. I think we'd all agree that would be a wonderful thing. But given that time is slightly tight, and we've got Paul Adams and Martha Clark and the CMC announcement at 10, and I'll try and be ready for that. But I think it's probably appropriate that there's still a bit of time for questions and discussion. So rather than wait at the end, I think it's probably a really good idea that we get everybody giving me the standing ovation now. Just make sure that we don't miss out on that opportunity to say thanks for a wonderful talk. So if you could all show your hands and give me a clap, that would be amazing. What it is to be able to conduct spontaneity, I think that's a wonderful thing to be able to do. Thank you, everybody. You can stop now. So today's more focused on commercial disputes, not family or workplace, not because of any other reason than simply I don't have the skill set or experience in those areas. But I do hope that what I have prepared, while focused on commercial matters, still has some, and I think it does, relevance and crossover points to think about and digest. And I'm sure that the concept of dispute avoidance and volcano insurance does have some applicability in those areas as well. So assisted deal making and preparing collaborative contracts. the first step in effective dispute avoidance and resolution. I think it's fair to start with what is dispute avoidance. Dispute resolution is, of course, a term we all are aware of, but dispute avoidance is perhaps something a little less well known. It is coming in and it's beginning to be referred to, but it's by no means even close to an accepted phrase. It's perhaps a little like the slow creep of the language change from commercial litigation to the commercial dispute resolution to dispute resolution. And I've been long enough in the game to have qualified into private practice as a commercial litigator. So I think that the language is changing. It's just not an overnight click of the fingers one, but I think it's coming. So dispute avoidance, and I do include throughout this morning the terms conflict avoidance and risk avoidance interchangeably. So when I refer to dispute avoidance, I am including conflict avoidance and risk avoidance. But the DRP and its consultants consider it to be the rather simple and obvious concept, or at least we believe it to be so, that dispute avoidance is the concept of avoiding, or at least attempting to avoid, an issue or disagreement escalating into a dispute event, where then litigators, lawyers, barristers, experts become involved. And then, of course, ultimately, adjudicators, arbitrators, or judges then become the primary stakeholder or determining a dictated outcome, rather than the parties to the contract itself, agreement or relationship, be in control of their own future and outcome. Note, of course, that I've not included mediators in that rather lengthy list, because the DRP and its consultants see and absolutely endorse the need for the use of mediation. But of course, to mediate a dispute, there has to be a dispute in the first place. And of course, I'm talking there about the general dispute resolution, ADR, mediation process. So I'm suggesting, and it is of course only a suggestion, that dispute avoidance is a concept or notion of far greater and earlier mediation or outcome-focused discussions than waiting for the traditional appointment by lawyers of a mediation at some point, say after filing of allocation questionnaires and a stay has been put in place. So in essence, dispute avoidance is naturally and quite obviously focused on prevention rather than a remedy. Naturally, it's not appropriate to refer to a typical mediation scenario as dispute avoidance, dispute management for sure, and dispute resolution as a certainty. But after all, and when all is said and done, it's better for the commercial client, and indeed for the protection of ongoing and potential future business relationships, to avoid a dispute than to manage or resolve one. A constant driver here is that the parties, when a settlement has been reached, often declare, should have done this sooner. So dispute avoidance will hopefully be one of the golden threads through the rest of this session. But please, if there are questions, as ever, just feed them through the chat function. Hopefully there'll be time to pick them up now, particularly as the ovations got out of the way. So that's dispute in avoidance in an absolute nutshell. But as for volcano insurance, it's the insurance policy that no one thinks they need until, of course, the dispute event has erupted. So volcano insurance is intended to assist in the understanding and buy-in, if you like, that there are actually a whole host of processes and options in place and readily available by not using the tried and tired systems of old when dealing with commercial contracts and agreements to both prevent early conflict and protect communication at the start, and to create long-lasting relationships, and all before any volcano or dispute erupts. That's ultimately volcano insurance. So the concepts of dispute avoidance and volcano insurance are all about early and collaborative engagement, focusing on the very start of a commercial relationship. Everything, when all is said and done, is about relationships and how a positive one will create and engender an atmosphere of collaboration, engagement, and understanding from the outset. And even when a dispute arises, the risk of such an occurrence causing permanent damage to the relationship is far greatly reduced through dispute avoidance and the focus on effective relationships and dialogue. David, or Dad to me, would often declare that you work with what you've got. So applying that, if you've got a relationship based on collaboration, engagement, and understanding, then communication will be easier, even if difficult conversations are required, thereby avoiding risk and conflict and avoiding a dispute event rather than managing or resolving a volcanic eruption-esque dispute. And this will clearly save a lot of time and a lot of money. So assisted deal making, and it's not a new phenomenon, this. Charles Middleton Smith and Ed Moore, who I'm sure many of us will know, talked about this in an article in the International Bar Association newsletter back in 2007, so what, 14 years ago. But the DRP sees assisted deal making, or deal mediation, as it's often interchangeably referred to, as a neutral or mediator being retained by both sides and working between those contracting parties, teams and subsets if they're required, to help maximize a structure and a timetable for the negotiations over the detail of the agreement. This will create a culture of collaborative engagement and understanding in relation to the discussions. And as a direct consequence, the final agreement will be as solid and free from the dreaded imbalances or desires to get them back next time or anything like that, which normally pervades the corridors of court, as those litigants search in vain for justice and someone to see the case from their often inherently biased viewpoint. So the use of assisted deal-making techniques when the parties are at the discussion and negotiation stage of a commercial relationship is absolutely vital and is truly the first stage of dispute avoidance. And it's also a solid application of volcano insurance. So it's about getting it right from the outset. And that's really what dispute avoidance and the concept of volcano insurance is focused on. A well-drafted, structured commercial contract is the cornerstone of modern business, right? That I'm pretty sure we can all agree on. But of course, well drafted and structured might not necessarily mean the same thing or have positive impacts for the commercial parties, right? But without a contract or set of terms or conditions or agreement that's fit for purpose and of satisfactory qualities for the contracting parties, the scope and propensity for issues to arise and disputes to erupt is massive. It's perhaps even more alarming than that, actually. It's probably probable and not just possible that parties to a contract or set of terms, whatever, that are not fit for purpose will be involved in disputes and litigation before their commercial relationship concludes. I mean, ultimately, what is the point in that? So most commercial disputes, but I accept not all, can tend to be traced back to the contract and the terms, or a breach or a non-compliance point, or if you like, a dispute event arising from that agreement. So commercial parties to a contract lean to agreeing broad arrangements and then allow the lawyers, external mainly, but some companies have in-house, and then they pour over the items and add the detail in, right? Now, I'm not talking about every deal here. I'm not talking about the multi-million-pound contracts or indeed the few £1,000 ones either. I'm talking generally. But it occurs to me that the tired and tried lawyer approach of drafting versions back and forth and back and forth and back and forth, track changes everywhere and umpteen drafts, whilst important, it of course does beg the question, important for whom? Now, most of the businesses just simply want the agreement done as best they can, for sure, but get it done, get the contract going, get the goods or the service or the transaction or the money flowing. They don't necessarily want to be subjected or stymied by contractual negotiations over the minutiae. Now, of course, it could be argued that for sure lawyers are absolutely vital in concluding the fine print, devil's in the detail after all, right? But they must not run the deal or morph what the parties understood into an overly complex, sometimes argumentative, and simmering agreement, which has no volcano insurance protection or dispute avoidance provided into it either. So engagement is everything, everything. Engagement means far more than just communication, of course. The engagement of the parties, or as I'd like to reframe the word parties now into partners. So engagement of the partners to the contract or the agreement needs to occur from the very outset through effective communication and a focus on delivering, maintaining, encouraging collaborative relationships and negotiating intelligently. This will only lead to a finalized agreement that reflects in a far more balanced fashion the commercial intentions and needs of the partners and not necessarily the drafting preferences of lawyers. So if the partners are not actively engaged in the conclusion of the final written agreement, just say the initial headlines, and the rest is left to the lawyers or accountants or technical experts, then there's a real risk that the final term presented for signing does not actually reflect the genuine aims or initial intentions of the commercial partners that the partners may have agreed in the very first place. It could even be the case that what is prepared, whilst correct in law, is utterly at odds with what was expected. And this does not start or even bode well for anyone. And as a worst case scenario, you've got a dispute right there and then, right? You've got a final commercial agreement that either won't get signed or one side feels so aggrieved that they look for any excuse to get one back, we'll get them next time, you know, down the line. Any of those situations, and probably several others too, are, a genuine and possible reality. And that's not dispute avoidance at all. It's dispute creation. So, of course, I accept it might be that those sort of circumstances that I've just talked about are most likely to occur when one business or one side is unrepresented and has, with the belief that it would be far more cost effective for them to allow the other side to prepare the documentation, or perhaps where one business presents its standard form, standard terms. This is our normal agreement, whatever. And in a haste to move forward, the fine print has not even been checked, reviewed, understood, or sometimes even read. This, in my experience, occurs far greater in the construction industry than any other. So you get a main contractor pushing subcontractors, and they enter into terms, or the subcontractor, has a sub-contract with their subby. And there's a rush to get going, secure the work, maybe even based on the whispered promises of more work if this one goes well. So they don't look at things like the warranties or the indemnities or the program dates, LADs, contract charges, payment terms, retention levels, and so many more things. And they're not just taken notice of, they're just sometimes not even acknowledged. And again, this is just setting up everyone, or every partner potentially, up for a dispute event or a volcanic eruption. And this is most definitely not dispute avoidance, and it's more akin to dispute creation. I accept, again, that the equality of bargaining positions between the parties who are negotiating or preparing a contract is not that common. So again, in a construction industry scenario, a subcontractor is often more likely to have more adverse terms imposed by the main contractor. And of course, in turn, the main contractor has probably got onerous terms imposed upon them by their employer. But in this type of situation, where it's less of a buy-sell transaction, the actual engagement of the partners in the drafting and formation, amending, negotiation, finalization of the contract or terms is just so fundamental in order to avoid the occurrence of a dispute event that it has to be the focus of the partners. And of course, we know in the construction industry, again, that there's the traditional suite of JCT contracts, right? The joint contract tribunals. And whilst used a phenomenal amount, the actual mechanics are at times, and only at times, stressed out. So heavily amended with changes to articles and words being deleted and replaced, or clauses being substituted, etc., etc., etc. That often that the original JCT can end up being a pale shadow of the versions placed before the partners. A practical example of this, if I could, just briefly, and it occurred late last year. The DRP was approached by a subcontractor, and they'd successfully won a contract with a main contractor. We'll call it design, manufacture and installation of certain construction items. So the agreed contractual price was a little over £10,000, and the subcontractor was set to make 20–25% margin, max, absolute max. The main contractor sent over their standard paperwork, and it was almost 125 pages of documents ranging from methodologies, health and safety, risk assessments, etc., 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 as well as obviously a JCT subcontract design agreement. But that agreement had page and page and page of amends. Replace this word with that, replace this clause with that, not applicable, this clause over here, this clause over there, take this out, add this in, etc. And the subcontractor was mindly to blindly sign, as often is the case, and return it. And that's, of course, their commercial decision and their business prerogative. But one of the questions posed to me very early on was, why is it meant to be a standard agreement when there are literally dozens of pages of changes? And the margin for the subcontractor on a 10 grand contract was between £2–2.5 grand. So yeah, max, absolute max. And that's nice money, right? I think we can all agree that's good money. But after a brief discussion with the subcontractor, it was established that retention was set at 5%, payment terms were 20% against the main, and then a very convoluted payment process thereafter based upon the main contractor's program. And LADs, liquidated ascertained damages, were stated to be £3 grand a week, uncapped. So a short synopsis of what happened later was that the subcontractor was able to discuss adopting basic principles of assisted deal making, deal mediation, and also obviously dispute avoidance. They raised a number of points with the contractor. The contractor openly admitted that they'd just sent over their standard terms, standard docs. And ultimately, through the process of collaborative engagement, a fairer and more balanced agreement was concluded. The project and the subcontract works proceeded with no issues whatsoever. There was absolutely no residual resentment, and that's an important phrase. And the main contractor placed earlier this year, on similar terms to the final ones that were agreed, a much larger order with the subcontractor. Everybody won. And that naturally focuses the mind, or at least my mind, on whether template agreements or bespoke ones are better for the partners in relation to dispute avoidance and deal mediation. So there's no settled thought about whether it's better to use template agreements or draft from scratch. Most of what the partners actually need is infinitesimally small compared to what advisors assert is paramount to include. I accept, again, that there's absolutely no doubt that a contract is always going to be more detailed than what the partners would consider they actually need in the first place. And it'd also be accurate to advance the point that agreements have been prepared and signed without legal input or advice can often lead to disputes over the interpretation and formation far more quickly than if lawyers have been involved. So all agreements need careful deliberation for sure, but it's neither prudent in terms of commerce nor law to expect one contract to be a perfect and exact fit for another, even if it appears to be identical. It's also not sensible commercial practice, in my opinion, to sign a contract without first understanding it. But both of these occur regularly and cause partners to become involved in disputes that could and should have, frankly, been avoided in the first place. And of course, it's important to talk about the accepted practice, albeit again, not always, that the boilerplate clauses, the set of non-operative provisions in a contract, are often drafted and reviewed as standard, dragged, cut, paste, move on, And although in principle, there's nothing obviously wrong with accepting the principles of the boilerplate terms to be included, the reliance on standard drafts is rarely a productive mechanism for an effective and commercial and successful long-term relationship. And it certainly doesn't fit with the concept of dispute avoidance, right? It could be argued, and I think probably successfully so, that a partner who accepts the other side's standard terms and conditions in order to avoid opening the proverbial can of worms does so at their own peril. Many businesses want to avoid the legal minefield of contractual debate and the travelling drafts that I referred to earlier. However, the simple reality of the situation is that accepting any terms without review or consideration may lead to a sense of injustice because they seem to be, one-sided, and they'll only tend to expedite the escalation and inevitability of a dispute event. And again, that's not dispute avoidance, that's dispute creation. And of course, it's easy for a partner to be wistfully reflective, right? With hindsight, propounding how unfair and how staggered they were that when a contract signed and accepted is exploited to the other's advantage. And courtrooms are filled with litigants demanding justice and fairness. But these equitable remedies are not always going to be possible, as the courts have declared that it's not their responsibility to protect commercial parties from a bad bargain. Prevention is preferable then. It is in the parties' long-term interests if they work together in a collaborative and open way with regards to the formalization of contractual terms. And that's where assisted deal making or deal mediation comes in. I mean, there's always going to be occasions during such discussions where elements of disagreements occur, but it's important to hold on to the fact that conflict can be positive, provided it's approached in a pragmatic way and presented in a non-hostile manner. The phrase of, raise your argument, not your voice. And a deal mediator here is expertly placed to ensure that any such occasions do not adversely affect the outcome, and that conflict, if it arises, is managed proactively, or that partners are able to avoid creating a point where effective communication breaks down. The deal mediator can also assist the parties in concluding a final agreement that's not only going to stand the test of time because it's been negotiated in a collaborative and engaged fashion through assisted deal making and the use of a deal mediator, but also it's going to stand the test of rigor if, and it is a big if, an issue or dispute or disagreement arises. So assisted deal making. Negotiation, I'm sure we all do this. Negotiating a deal is something common to all businesses. It's the essence of what business people do most, if not all the time. However, it's not necessarily true that simply because you've experienced negotiating or you've got experience in negotiating, that you'll get the best result, or even that you're any good at it. There are many factors that go into a good deal through assisted deal making. And perhaps the most important is that there's a balance between the position of the partners. As we know, the traditional party's personal point of view is set out to confer the best arrangement for themselves, right? Often failing to recognize the position of the other. This is the much talked positional negotiation. And it's probably quite natural, but it does not necessarily lead to the best result, for it allows impasse to develop in the negotiation as each side scrambles for their position to be accepted. And indeed, many negotiations fall down because the partners have not refused to recognize the needs of their counterpart. The tired and tried, salami slicing approach or playing hardball is not conducive to anything other than dispute creation. And where such deals are made, they are often assessed and treated as a dispute waiting to happen. So the use of assisted deal making and deal mediation can help partners recognize the needs and interests of the other partners. And by doing so, this will make better, more collaborative, more engaged and longer lasting deals. So the method of the method of deal mediation and the role of the deal mediator has a lot of the same attributes and characteristics as a typical mediation and the mediator's role. But of course, bear in mind, there's not been a dispute event. So as mediators, many, I'm sure you all will actually, recognize many of the following in relation to deal mediation. Helping the partners to move from positional negotiation to interest-based considerations, clarifying issues and interests, and in particular, each other's needs, breaking down obstacles, dealing with smaller issues one by one, reality testing and fact-checking positions, use of collaborative language, changing the balance of risk and reward sharing, helping to frame the process made towards the structure of the final deal, instigating working groups and to deal with specific issues as they arise, taking strategic breaks and allowing cooling off periods if need be, identifying potential solutions to break deadlock, and obviously the last one, foreseeing trigger points and structuring positive processes deal with potential conflict situations. But as for what specifically a deal mediator brings to the table, each side to a commercial negotiation would historically and frankly naively manage their risk and look for the personal benefit by regarding the other as an opponent. This attitude to negotiation creates distrust and doesn't create any sense of collaboration, engagement, or understanding. And again, it's more akin to dispute creation than the dispute avoidance. So when the deal mediator, what the deal mediator provides is assisting in the addressing of the issues or deal points, if you like, or mechanics from an objective and neutral position. The deal mediator creates a realistic and pragmatic view of the other partner's position and intention. The deal mediator can also provide the partners with a structure and timetable, just as in the commercial dispute, of course. Partners can be briefed beforehand on what is needed to be prepared for in the negotiation and what will be expected. And this will include a framework in which parties are encouraged to collaborate and engage on their needs and objectives in a constructive proposal that benefits and secures the overall agreement. Within this structure, of course, the deal mediator will work to facilitate a collaborative agreement that is readily and willingly acceptable and agreeable to all the partners. The tool known to all mediators, and all of us here today, of reality checking will support the partners in moving away from positional negotiation to more interest-based considerations. The deal mediator will engage with the partners, both jointly and separately, to establish the relevant contribution and best outcome for the final agreement. And if need be, also create sub-teams, working groups to focus on specific points. And this is quite an interesting one. The deal mediator will also be able to gauge the strengths and weaknesses of the people present and determine how best to utilize interpersonal relationships. And this helps the partners to create effective negotiating teams and to set realistic and achievable timetables and agenda items, and to assign a role for specialists, including technical experts, accountants, and of course, lawyers. The structural framework put in place by the deal mediator with engagement from the partners is a major element in agreeing an effective and successful conclusion. And of course, safeguarding dispute avoidance. So the structure of the deal mediation will involve roundtable meetings, of course, and private meetings, and it might be necessary to have private meetings in order to fact check or reality test and so on. But there is value in the deal mediator challenging the partners and the deal, more than perhaps a mediator would in a typical commercial dispute, as the deal mediator can make suggestions for consideration and further discussion as to potential outcomes, as well as, of course, being creative in suggesting alternative or hybrid structures for the partners to further consider and discuss. The challenge for the deal mediator is to balance what each partner considers to be a fair apportionment of risk and reward. But through the deal mediator, momentum can be energized, and hopefully, and I believe this, a truly win-win outcome can be achieved. The deal mediator can also engage the partners and indeed their advisors over collaborative negotiations and discussions in relation to the boilerplate provisions. And of course, it's right there that you talk about escalating dispute resolution clauses. You know, the inclusion of a bespoke escalating dispute resolution clause often offers that extra level of volcano insurance in a very, very unlikely event that an issue or dispute, issue or disagreement turns into a dispute event. The advantages of having these discussions at deal mediation stage is that the partners can collaborate and engage over a pre-agreed set of processes to avoid a dispute event and to prevent, if you like, the volcano erupting. So the basic principle behind escalating dispute resolution clauses is to resolve disputes. You know, it's not an alien concept at all. But the use of them isn't mainstream either. I mean, I personally prefer them to be called tiered dispute avoidance clauses, but as ever, that's a classic reframe. But it often makes me smile, well, it's grimace really, that some contracts that have a dispute resolution clause in it just cites the jurisdiction for legal proceedings. But a tiered dispute avoidance clause agreed by the partners in a deal mediation situation would prevent the absurdity that I'm sure many of us can recall or be aware or have heard of, where warring parties want to dispute the dispute resolution clause itself. And moreover, I think it's utterly nonsensical, but sadly quite common, I think, that a boilerplate dispute resolution clause actually has no practical benefit. For example, the classics of a clause that cites the use of arbitration, but the contractual quantum is so minor to make arbitration completely and utterly prohibitive, or where the arbitration clause doesn't provide for a stay in the contractual program or timetable. Or another example would be where a JCT contract, say, refers to adjudication, despite it being a right under statute and therefore bound in any way. And also, that would be a classic example of an opportunity lost for the use of a mediation clause. And I think we can all agree here today that mediation is the most party-focused method of dispute resolution. But if a JCT is used and a dispute emerges and people creep over to where they might have discarded the signed copy, having forgotten about it, and they pick up the amended clause 9 and it cites the banal but often quoted and used, a party shall give serious consideration to a request by the other to use mediation. I mean, it just seems completely ineffectual and lacking any semblance of practicality to me. Or maybe they'll be unlucky and they'll have a clause, an amended clause 9 that decrees arbitration or adjudication, which of course, as we know, on the scale or spectrum of ADR processes, is certainly at the imposed end. And that neither seems sensible or a one-stop option to embracing any degree of collaboration or engagement or common sense compared to the use of deal mediation in the first place. And also, of course, the rapid availability of mediation generally. So I believe that it's of paramount importance that the partners work together on this carefully and suitably worded tiered dispute avoidance clause to make sure that it really is fit for purpose. And the partners understand what's being agreed to and the why of why they're agreeing to it. And everyone has agreed to the dispute avoidance process. So dispute avoidance clauses include a number of stepped processes. And I've just referred to that as a dispute avoidance process, but again, that's a DRP and consultant reframe. But such processes include good faith partner-led discussions, expert-led engagement, and then if need be, a formal mediation. But all of this can be operated and undertaken on a pre-action stage, i.e. before legal proceedings have been issued, and hopefully before they've even been contemplated. And of course, lawyers, counsel, technical experts can be utilised if need be at this mediation in the normal way. And also there should be no limit on the amount of tiered dispute avoidance clauses and the use of it. And the dispute avoidance process can be used by the partners during the term of the agreement for as long as they need to, for as often as they like to. Not just a one-stop, oh, we tried it once, let's move on. So if the dispute avoidance process or tiered dispute avoidance clause has been worked through together and realistically, and sadly there are no guarantees in life, but the odds on of a volcano erupting and causing irreparable damage to the relationship through dispute escalation or litigation should be as negligible as it possibly could be. And the DRP passionately believes that no business starts a commercial relationship looking for a legal battle, right? Or a dispute event. No one buys property next to a smoking volcano, do they, right? Partners should be involved at all stages of the dispute avoidance process, as they need to assess the risk, if any. And the partners will remain intrinsically involved in the decision-making process because they're the only ones who can decide if the risk is worth taking. And of course, they'll have understood the other party's position based on the earlier comments relating to collaboration, engagement, and interest-based considerations. But perhaps most importantly, the dispute avoidance process or tiered dispute avoidance clause enables the partners to be in control of the outcome. And that's an integral part, if not the critically vital one, of securing effective and genuine dispute avoidance through deal mediation. So assisted deal making in preparing collaborative contracts is truly dispute avoidance. And if it's done effectively through partner-led engagement, there's no reason at all why there should ever be a volcanic eruption. And of course, I mean, note that lawyers, accountants, technical experts, in-house counsel, whatever, all have a part to play in assisted deal making, and their collective and individual inputs will be vital to secure the long-term progression of the relationship after the agreement's been signed. And of course, assisting the partner in preparing their best points. And best points, of course, is so much more than leading with the strongest point. These points, or best points, have to be persuasive and stress tested and presented appropriately. And a deal mediator can help in devising those bespoke structures and forums for such discussions to occur openly and freely. Such an approach is far more likely to encourage greater collaboration and a coming together or a closing of the gap, thereby leading to the effective outcome that the parties ultimately desire, right? A balanced, collaborative agreement designed for long-term profitability and success based around shared interest-based opportunities. Add in the overall protection, the volcano insurance, which of course is manifestly focused on preventing a descent into the perilously uncertain waters of litigation. And you're looking at a truly win-win contract that will benefit all partners. And that can only encourage future commercial relationships, partnerships, and shared opportunities for expansion. It is fair to say that there might well be disagreements or rubbings or differences, if you like, and it'd be naive to suggest that every contract prepared through deal mediation is going to be all skittles and rainbows. But adopting a collaborative, engaged process at the very outset, getting it right from the start, in the contract preparation, through assisted deal making and the use of a deal mediator, there's no reason at all why anyone has to get aboard the litigation gravy boat. Because the balance and the collaboration and the control of the parties on the terms and the outcome, and as well as the engagement of their advisors, is going to break the tired and triad, one-upmanship and escalation, and really offer dispute avoidance, not dispute creation. I mean, nobody wants to be reminded, I'm sure nobody wants to be reminded of Voltaire's comment regarding legal action, right? I was never ruined but twice. Once when I lost a lawsuit and once when I won one. And Voltaire's, simplistic view rings true as it did, now as it did in the 18th century. Litigation in any guise, wherever it's carried out in the world, in whatever forum, rarely brings the benefits sought and often comes at too great a cost for the litigant parties. A judicial process, while claiming to ultimately lead to the determination of disputes, traditionally leaves both the successful party and the losing one ultimately dissatisfied. It's because the parties have turned the dispute and the decision over to a third party to preside over. And even direct representations to that judicial entity have been curtailed through barristers and solicitors and experts. Control's gone. Control of the outcome is utterly gone, as has control of the process, and of course control over the costs in time and money has long gone too. And it's worth saying that the costs in litigation are, of course, not just the costs of the litigation itself or the arbitral process. Now, there's lost opportunity costs. They've got to be added in. Costs lost on business relationships, management, employee time, on preparing the case, diversion of resources away, reputational cost if the case is newsworthy, uncertainty over the share price if it's relevant. And there's little, I don't think there's any debate actually, that contentious litigation destroys relationships, robs businesses of vital resources. And that doesn't even address the personal emotions, right? The stress, the anxiety, the worry for your job, worry for the outcome. You know, maybe even if you win, you know, is it going to be a positive outcome? Can the other side pay? You know, can they afford to? Will they even? This kind of apprehension and fear cannot be conducive to any type of positive or progressive relationship. So the use of dispute avoidance techniques, namely here in assisted deal making, is therefore providing the parties the antidote before the poison has been taken, okay? Or it's the volcano insurance before the eruption occurs. And candidly, who doesn't want that? When all is said and done, that what was said and done will still remain. And the need to win or to be proved right for yourself, your company or your peers, often there I'd say for the lads down the pub, but you know, that's not going to be happening for a while, sadly. But the impact on the future is so negative. Positive relationships and effective lines of communication are damaged beyond repair often during the heat of the battle. Too often litigants declared, I'll never do business with them again, or I'll never talk to that person again. And the polarization of viewpoints or legal arguments, or even the stances adopted by the lawyers will always widen the dispute gap. But if the parties were to accept that their actions, attitude, and approach could dramatically transform the dispute into one that is avoidable in the first place, then the outcome that will be achieved will be more cost-effective and harmonious, rather than being left with what's been said after the dispute event. And imagine just for a second what the benefits for everybody if what's left and what's being said has been said positively or collaboratively in contract preparation through assisted deal mediation and adopting dispute avoidance, and phrases are used like, I can't wait for the next time we can do business with them, or I've got someone you should meet. So when arguments and disagreements first erupt, like the volcano, if there had been a deal mediator present for assisted deal making, the odds-on fact is that the dispute would not have escalated to where it was. Or at the very least, a dispute avoidance process through a tiered dispute avoidance clause would be in place to stop the irretrievable damage of a volcano eruption. So, and the desire to claw back what was said or what was done is natural, of course, but it's traditionally quite a private emotion, right? You know, I wish I'd never started this. It's a commonplace sentiment during the rigors of a litigation or a heated battle. But actually, privately often, but I'm sure we've heard this, hindsight, I'd have done things differently. And that applies readily to all forms of disputes, for sure, not just legal cases. And there's often a mere handful of events or statements or actions, and sometimes just a solitary one, that created that dispute event or the volcano eruption. And it's impossible to stop it once it started, right? I've never experienced words, I wish I'd never started this, in relation to dispute avoidance or the collaborative preparation of contracts. I wish I'd never started. This is a phrase I've never heard when I've talked about dispute avoidance or deal mediation or assisted deal making. Everything, as I said earlier, when all is said and done, is about relationships and how a positive one will always create an atmosphere of collaboration and facilitation. And even when a dispute arises or an issue, adopting dispute avoidance and in a commercial context, utilizing deal mediation, there really should be no dispute event. So assisted deal making and preparing collaborative contracts will provide the partners with a sustainable, achievable, and long-lasting commercial relationship. And particularly in these times, that's got to be a positive force. And then with the inclusion of dispute avoidance and a dispute avoidance process or volcano insurance, if you like, that will be a consideration for all. And it perhaps offers the simplest of things, the benefit of hindsight beforehand. Thank you.
Thanks, Ollie, very much for that. I think we started a little later than we expected for your good self. So I think we've still got some time for some questions, if that's okay with you, Ollie.
Of course it is, absolutely. I was watching the clock a little bit. I'm conscious that I don't want to step on Paul and CMC's toes, but yeah, absolutely.
Okay. What I'd like to do is to invite anybody who's put anything up on the chat to repeat a question if it hasn't already been covered. But can I throw one in, Ollie, please? I'm usually or often involved with construction disputes, as you are. And there's the concept of the project mediator in that, where there's a mediator appointed right at the beginning, who sees the whole project through, attends design team meetings, attends site meetings, and is there then primed and up to speed when any problem comes up. Do you see the prospect of the deal negotiator or the documentation mediator going on to do the same role?
Are you thinking about what? Are you thinking there about conflict potentially?
Yeah.
Yeah. I mean, it's something that it was a question that I was expecting, Dave. I wasn't expecting it from you, but I was.
All right. Apologies.
That's all right. That's all right. I think that's an interesting one, because I think as mediators we are always concerned or not concerned, conscious of perceived conflict, because the impartiality of any mediator in any form, family, workplace, commercial, construction, whatever, is one of the absolute bedrocks of a successful mediation. And of course, if one side has any thought or belief that there is an imbalance of neutrality, then that can not be a good thing. I think you're absolutely right to talk about project mediation. It's great. It's not used enough, though. For me, I think it's very much a case-by-case basis. I think it comes down to the relationships, it comes down to the communications. But again, it's also about whether the conversation's been had early, right? It might be seen to be having a difficult conversation early, as I mentioned in the short presentation I just gave. I think if there is an engagement and it's happened too late, then I think the mediator should probably stand aside. But that's probably more a professional opinion, a personal one. I'm sure many others would disagree, simply because they know what's in the stationery cupboard, if you like, right? They've been involved, they know what's going on. Why spend X number of hours or money or whatever when getting X to get up to speed when I'm already up to speed? But again, I'd encourage that situation, again, on a step process, adopting that sort of tiered avoidance process or tiered avoidance clause. I'd encourage that to be in there openly, honestly. And if there is any perceived and I think it would be perceived imbalanced, then the mediator should do the right thing and step aside. But that doesn't necessarily mean that there still can't be a role for that original project mediator. But I think project mediation is a really interesting concept, and it's of course very akin to what I just talked about in relation to assisted deal making. But again, I mean, you know, you work in very much in the same industry as I do, mainly the construction one. It's not as used as often as you think it should be, right?
No. Thanks, Ollie.
Pleasure.
So can I invite anybody who's put anything up on chat as a question, if they still want to ask it live, as it were?
Hi, Dave. Yeah, if I may, just continue on what you were talking about, the project mediator, which is a new term for me. Obviously, I've worked out in the Middle East quite a lot. And obviously the DAB or the DAAB or whatever you would like to call it would take on that role. And Oliver, you talked about conflict there. I'm just trying to understand, if these guys are engaged at the start, they normally go through the whole project, being engaged and proactive early. So I think it's a good thing that they are so familiar with the project that they snub potential disputes on the head, if you like. And I think it's a great thing. Also, another point I would like to ask you about is, I think within the mediation, particularly within the ADR regime, I think there's a lack of education. Would that be a fair point? That people don't understand fully the benefits of bringing a dispute or potential dispute to the likes of a mediator who can, again, cut it off at the pass and, you know, retain business relationships. That's what it's all about at the end of the day, and reduce costs. Have you any thoughts on that, Ollie?
Well, Liam, great question, and nice to see you, and thanks for joining today.
Cheers.
Absolutely, I love that phrase. You know, cutting it off at the pass. You know, offering a different route. And you're absolutely right. You know, mediation's been around a long time. You know, America in the very, very early 90s first came over here, 91, 92, when Dad and many others were first trained and CEDA was formed, and obviously it's come into the huge industry now. And I think we're all educated, knowing purchasers, knowing the absolute benefits of mediation, but still you talk to, particularly in the construction industries you talk about, the oh no, don't mediate, no, my lawyer says, or I've never mediated, or worse, and we've all heard this, oh, I mediated once 6 years ago, it was a complete disaster, I'll never do it again. You know, and I think you're absolutely right to talk about education, and that's one of the great things about the Mediators New Breakfast Club, because it's continuing to have these presentations, albeit online at the moment, but it's people talking about the concepts and the growth of the industry. And hopefully, and this is a personal opinion, and I accept it's an absolute personal opinion, that as an ex-litigator, the role of the lawyers in determining the when and the why and the how of a mediation sometimes I think is adverse to the parties. The mediators, the lawyers know a great deal about mediation, and some are pro, some are anti, some will use it as an advantage, some will use it as a good day to earn some good fees, preparation time, etc., etc. The education that you talked about has to be with the partners, as I call them, or the contracting parties. That's where the education needs to happen. They need to realize, again, construction, but it works for any industry, I think, Liam, that they need to understand that there is a process, and that whether you're laying brick or whether you're supplying foam parts, or you're mowing grass, whatever it is, there's going to be potentially a conflict or an issue or a rub or disagreement down the line. So let's get it in place. It is volcano insurance. It's a thing you might never need. How many times have we all heard, particularly again construction, no need for contracts, this one's going to work on time, on budget, everyone's going to make a fortune every time, and you just look at them and go, okay, I love it, I love the passion, I love the belief, but could we just slip in this little clause? If we don't need it, brilliant, But hey, if we do need it, it's there. And that's part of the education about dispute avoidance, the use of mediation, dispute resolution, dispute management, DABs, as you mentioned. And one of the consultants of the DRP Wolf is a big proponent of DABs, dispute avoidance boards, and project mediation that Dave Owen used. But again, it's, if you don't need it, well, hey, what, you've got 1,000 other clauses that you don't understand, warranties or indemnities or collateral warranties and all these things that people pretend they understand them. They don't, but they go in the contract. Why not put a tiered dispute avoidance clause in? It's and there it's there, and hopefully you'll never need it. But do you know what? If you need it, it's there. And that part, and that's the phrase about education that you're so right to bring it on. Cut it off at the past. Have it there. It's offering a different route. And it's a great question, and I thank you for it.
Thanks for your response.
Pleasure.
Ollie, forgive me if I could ask a different question from the one I put in the chat. Morning to you, by the way.
Morning.
Why do you think assisted deal mediation wasn't used for Brexit?
Well, there's a question. I mean, why wasn't mediation used for Brexit? I mean,
yeah,
it wasn't, I mean, we won't stray into the various politics of it, because I'm sure people have got different opinions, and I know obviously we've got colleagues from Northern Ireland and from the Republic of Ireland, but I think, why wasn't it used? I mean, it comes back to Liam's point about education. It comes point to the fact that actually I don't need to be told how to negotiate. I negotiate for a living, and I think the lack of education, the lack of realization that it wasn't going to be smooth, calm waters. I think, I mean, I wasn't there, but I mean, after the referendum, it's funny actually. It's funny you bring it up. The Thursday was the referendum. The Friday, I was down giving a talk on mediation at an international seminar down in London. And of course, I got there, and well, nobody was there. Well, very few people there, and no one was really paying attention because everyone was talking about Brexit. And I remember when the referendum result was called, very, very late or very early in the morning, I was watching it, sat in bed, and I elbowed the wife and said, "We've left." My wife's response was, "Could you leave quietly?" So I remember talking about an opportunity for mediation that very next day, not part of what I intended to speak about at all, because I didn't think we'd leave, but personal opinion. And so many people nodded and they talked about mediation. Mediation is so ripe for this. And it should have been a huge team of mediators. It wasn't used, but I think assisted deal making and the concepts of it, but even the concepts of mediation, should have been utilized during those torrid and protracted Brexit negotiations. But as I said, and as I concluded with the presentation I've given, right? It's the benefit of hindsight beforehand. It's always 2020, isn't it? It's always 2020. And now we're in 2021. And I think it should have been used personally. I think it would have added immense benefit. I think there could have been a huge number of talented mediators, not just from the UK, but of course from Europe, of which there are thousands and thousands of hugely talented mediators. The discussions and negotiations would have been far better and far more collaborative, and probably a bit quicker if mediating and mediators and assisted deal making and so on had been utilized. I think it's probably a regret, but that's a personal opinion. But it's a good question.
Thanks, Ollie. I just mentioned it because maybe there's some commonality with what you've been discussing, in the sense that maybe at least one of the parties involved, or partners, as should have been, actually perceived they get a better outcome. Some might consider they did get a better outcome, but of course we know that the real outcome is in the future, and the level of trust that remains when other issues crop up in the future.
But Vernon, that's absolutely spot on, isn't it? That's why the mediators are here today. It's why, there's, Dave Owen's got a list of hundreds of people. That's why there are panels, and of which you're a member of many excellent ones. And I think, Vernon, you're absolutely right that's where the mediators and the mindsets and the people who are first time joiners here today talk about. I absolutely see the benefit of it. And one of the chaps talked about I mediated a neighborhood dispute, and and that's a real example of living and breathing a proper dispute. One that you wake up with every day, whether it's a boundary dispute or a workplace one or a commercial one, of course, family one. And I think you're absolutely right. The engagement of mediators using the skills that we all have, could have and should have got a better deal for everybody. And therefore it would have actually meant that the future, whatever the future may be, and of course it's difficult to talk about it, Vernon, of course it is in these funny COVID times that we're in at the moment, but who's to say what would have been? But I think you're right. I think absolutely hindsight is 20/20 when people go, I should have used mediation. Why didn't I use mediation? But of course they started, in my opinion, they started slowly, they started badly, and the negotiation position never really got going. But I think if they'd operated a project mediator that Dave Owen talked about, or assisted deal making, or just got a suite of mediators in to talk, then it would have been, could have been, perhaps should have been a different outcome. But Brexit and mediation, I think, is a topic that we could all talk about for hours. And I think, hopefully, we'd all agree that it should have been used. I mean, it might have been used. It might have been used. We don't know. We weren't inside those rooms, right? It might have been used. But again, it could have been an example that we all know, Vernon. I used mediation 6 weeks ago, 6 years ago. It was a disaster. I'm never doing that again. And we know that doesn't fly. That doesn't work. Who knows? Good question.
I don't think it was used, Ollie.
Well, you're probably right, Vernon. You probably know more than I do, but with your red line phone to Downing Street, but who knows? I'd like to think it was used, but I'm pretty sure it probably wasn't.
I think we've got about another 5 minutes before we hand over to Martha Clark. So maybe a time for 2 or 3 at the most.
Sure.
More questions or comments, please. Anybody?
Hello.
Yes. Hi.
Hi. All I wanted to say was that yesterday it was announced that there was a new regulator for the buildings trades out of the terrible Grenfell situation. So I think that what you're talking about, being really, really intelligent about drawing up contracts that, work for both partners, also would have more than a nod to the fact that nobody wants to get in trouble with a regulator that's actually going to have some teeth this time around.
I think you're right. I think that I talked about it a little bit. The worry, the fear, the anxiety of being involved in any situation, and whether that's one heavily regulated or whether it's an unregulated or a dispute that you might have had in the classroom, of course, or a dispute that you might have had with a member of your senior leadership team, or a difference of opinion. And I think that often the worry of taking the first step can stop you taking any step at all, and that's when inactivity can actually cause the dispute event to actually occasion far more quickly than if a difficult step or that difficult conversation was owned or taken. And I think that's where the use of mediation techniques, us as mediators, us as project mediators or assisted deal makers, or whatever you want to call us, or family, employment, workplace, whatever, education, whatever it is. I think sometimes the paralyzation of fear will stop any momentum towards a mediation or a collaborative discussion or a facilitative discussion actually taking place in the first event. And that just extends the life of the dispute. And of course, the longer the disputes go on for, unresolved disputes go on for, there is a terrible lean towards the demonization of the other side, and that there is a projection of all of one side's issues, woes, financial difficulties, whatever it is, onto the other. And again, that's where the use of mediation, particularly mediation generally, and the soft skills of mediating and mediators that we all possess, could have been employed then. But as for a regulatory point of view, I would like to see, regulators being far more proactive in the use of dispute avoidance, early mediation, not allowing it to start going through, arbitral or complaints or legal processes. But that again is something that I'm sure all of us, all 68 or 69 of us on this call would probably agree with. But I think it's a good point you make. It's a very good point you make, actually.
Thanks, Ollie. I think we've got time for one more comment or question, please. Anybody?
Dave, it's Michael.
Yeah.
I was just going to say that thank you very much, Ollie, and thanks to everybody else for attending. But one of the problems we got here is that the politicians and their teenage scribbler advisors don't get any of this. They don't understand the value of what we might call our industry, which is worth, on any view, at least £1 billion a year to UK PLC. They continue, I've been involved in a number of initiatives, so I'm sure some of the rest of us have, in knocking on the Cabinet Office's door, emailing Dominic Cummings when he was in power, trying to talk to my local MP, which I succeeded in doing once, and so on. And the standard reaction seems to be that they're not prepared to invest in any of this. And if you look at what the World Bank and the other multilateral development banks do with dispute avoidance and adjudication boards, as they're now called, I think this is absolutely crucial. And clearly, public procurement is not going always swimmingly well. So surely any of this stuff is worth trying, worth some pilots. And yet there seems to be very little appetite for it and very little progress. And I think it's a terrible shame.
Can I just follow up on that, to say that there's an all-party parliamentary group on mediation, which some of you may have heard about. I've only attended 2 meetings, and in one of them there were supposed to be 3 parliamentarians there, but at one point there was only 1 because they were called away for more urgent business. And the meeting only lasted about an hour and a quarter, hour and a half in the first place.
Yeah, that's right, Dave. I've had been involved in a meeting with the Chartered Institute of Arbitrators and John Howell, who runs that committee, and the interest in, for what is, essentially the Brits, whether we're England or the United Kingdom or whatever we are on the day, kind of lead the world in this area, in this industry, and it's complete failure on the part of the government and other opinion formers that it's not recognised.
And that comes back to the earlier point about the education.
Well, there's a big job to be done there. I agree.
Absolutely. The parliamentary committee that Dave Owen that we referred to so rightly has been, it's not a new phenomenon. It's been around for years. Dad attended and was incredibly frustrated. I remember talking to him afterwards, and he was, and those that knew David or heard of him, he'd never lost his cool, but he used the word cross a lot. I'm cross was a dad phrase, and I remember talking to him, and we were having a coffee actually not far from Parliament, and he was saying, Ollie, I'm so cross. They just don't get it. They just don't get it. They just don't get it. I'm cross. And I said, well, let's talk about that. And he said, they just don't see the benefits. And that's years ago I'm talking about. So we're still talking about the need to educate. And I think you're absolutely right. Get in contact with, knock on the cabinet door, knock on knock on your MP's surgery door and talk to them about the benefits of mediation. And again, I'm not talking commercial here, but you're right. It's $1 billion saving industry, £1 billion saving industry. The money that mediating and mediators and mediations save businesses. Okay, it's not going into the legal coffers. Okay, well, personal opinion, we'll move on from that. But it's such a benefit. It can pervade everything, whether that's COVID, or whether that's regulation, or whether that's Brexit, or whether that's the use of the NHS, or interpersonal or inter-party discussions. I would love to know, and Michael, it's an interesting question here. Out of the 650 MPs, how many are actually accredited or even trained mediators? Not many, I'd say.
No, there's plenty of lawyers. So I should have been clear. I'm sure the savings are much more than $1 billion, but the revenue generated by the UK ADR industry, leaving out what used to be flights and hotels and other things. In other words, the fees to the people in the room, when what used to do is $1 billion. So it's revenue to the UK and must generate a significant amount of tax revenue as well.
There was a similar figure from one of the recent CEDAR audits, wasn't there? Mediation audits, where the cost saving was in the billions.
Oh yes, absolutely. Yeah. So the revenue to the UK PLC probably now exceeds $1 billion a year.
So I mean, it's about. So why is mediation so reluctantly used in or being accepted, or being mandatorily put through the court system? I mean, we've waited. I mean, Wolf Reforms 96, Access to Justice 1998, Irvine's Report 2001, and there's been creeps since the famous case of Dunnett and Railtrack and Horsey and Milton Keynes and all the rest of it, and it's continuing to creep through. We've seen a lot of great posts on LinkedIn about what Alan Ward said when he was on the Court of Appeal about mediation, and it's still even now not accepted as a mainstream thing. I don't know what the blockage is. Is it the lawyers? Is it the lawmakers? Is it the fact that there's a lack of general uneducation in relation to the benefits in relation to businesses? Or is it the fact that we've always done business this way? The company's been around 200 years. We've never mediated. Why do we need to start now? That kind of historically myopic and crazy attitude still exists today, Michael. And I think people we've got to keep pushing it. We've got to keep trying to raise it.
I agree. I mean, a lot of it has to do with the fact that whether we mediate, arbitrate, or adjudicate, or do dispute boards, it's all private. So it's not so much after. It's quite difficult. It tends to be under the radar. So I think maybe there's an opening for you, Ollie, and perhaps, Dave, we ought to wrap up and move over to the CMC. Yeah. But I'll just say that I think there may be an opening for you here, Ollie, as the mediation equivalent of Judge Rinder or Rinder or Judge Suzu.
Yeah. Well, I've got the shirt for it, so that's.
Anyway, thanks for you.
Thanks, Michael. Thanks, Dave.
Ollie, I think you're cross.
Cross. Yeah.
I'd like to thank Ollie again, and perhaps we can all
another thunderous
in the normal way. Thank you. Thanks, Ollie.
Thanks ever so much, everybody. I really, really enjoyed it.